Welcome. My name is Guylaine. I'm a white woman with curly brown blonde hair sitting at NYU University, and I'd like to ground us in a land recognition. The Review of Law and Social Change acknowledges the land politically designated as New York City to be unceded traditional territories of the Lenape and Canarsie peoples, Lenape-Hoking. That the lands were unceded means that title was never legitimately transferred to the European settlers, and that the existence of today's New York City required the violent dispossession and displacement of the Lenape and Canarsie peoples. NYU and the Review of Law and Social Change have failed to meaningfully acknowledge or take material action against our complicity in settler colonialism and continued violent erasure and dispossession of the indigenous nations and people. NYU is one of the largest landowners in New York City. We name these wrongs and situate them within the broader context of ruptured relationships between indigenous communities, governments, and institutions, the result of centuries of legal, state-sanctioned genocide, which continues to this day. We ask for you to join us in individual and collective efforts to recenter Indigenous perspectives, knowledges, materially support land-back movements, and build futures that celebrate the land, ancestors, and all future generations. Eve Tuck and Kay Wang Yang remind us that decolonialization is not a metaphor. Joseph Pierce tells us that the land exists regardless of settler acknowledgement, which can only ever be the first step towards meaningful action. Next steps involved building relationships with that land as if it were our kin, because it is. As we work towards dismantling the legacies of settler colonialism, we invite folks to interrogate your own histories and relationships to the lands we occupy and intentionally incorporate real material decolonialization into our liberatory efforts. We'd now like to introduce our editor-in-chief, Lauren, to give some opening remarks.
Thanks, Guylaine. Good afternoon. Hi, everyone. Thank you for being here. My name is Lauren Glasby. I'm a white woman with wavy light brown hair, wearing tortoiseshell glasses and a white button-up shirt with a black pattern on the front and sleeves. And I use she, her pronouns. I am one of the editors-in-chief of the NYU Review of Law and Social Change. And tonight I am so honored to be here with our journal's colloquia editors, Haley Corkery, Guylaine Pages, and Kira Taylor. We'd like to welcome you all to day one of Criminalizing Dissent, a two-part colloquium bringing together 20 organizers, legal practitioners, and activist scholars to learn more about the ways in which the state and institutions are suppressing radical justice movements, this repression's impacts on our own communities and communities across the globe, and the ways in which they can fight back against efforts to stifle the right to dissent. Each year, the NYU Review of Law and Social Change, an academic journal founded during the civil rights movement to support scholarship for social justice, hosts a colloquium on a complex and timely social justice topic with the goal of centering conversations that have otherwise been on the fringes of legal academia. This is an incredible opportunity to hear from people on the ground to better understand the through lines of suppression and of dissent in the United States and to chart a way forward together. I am so excited and honored to share this moment of resistance with all of you. And before we get started, I'd like to extend a huge thank you to our amazing colloquium editors, Haley, Guylaine, and Kira, as well as all of the incredible staff editors who've worked so tirelessly over the last several months to put this colloquium together. This event also would not be possible without our partners, DALSA, the Center on Race and Inequality, DALSA, the Immigrant Rights Project, LSJP, NLG, Outlaw, SALSA, SRP, and WALK, a complete list of which you can find in the brochure that you should have received via email. So this evening, we'll hear from two amazing panels, each running about 90 minutes, and then we'll leave time for questions at the end of each panel. We encourage you to send questions for the panelists by clicking the Q&A button at the bottom of your screen, and that'll make things easier for our moderators. But if you're unable to use that Q&A feature, you can also send questions by email to rlsccolloquium2023@gmail.com. That's rlsc COLLOQUIUM2023 at gmail.com, GMAIL. If you're an attorney seeking continuing legal education credits in New York State, you must have registered with us in advance and logged into Zoom with the same email address you provided to us prior to joining the event. Panel moderators will periodically announce and display for about 30 seconds CLE codes that you must write down and provide to us after the event in order to receive credit for attending. Each code will be read twice to make sure you get it. And with that, we'll turn things over to our opening panel, What is the Criminalization of Dissent, to set the stage with a discussion of the historical and theoretical roots of the criminalization of dissent in the United States, highlighting the tools of state suppression and key historical points of such interventions. This panel will be moderated by Nadia Ben-Youssef, a human rights lawyer by training. Nadia currently serves as the advocacy director at the Center for Constitutional Rights. Her work often centers at the intersection of art and advocacy, and she curates exhibits and artistic programming that document key human rights concerns, celebrate social movements, and allow creatives the space to chart the future. Central to Nadia's life work is a commitment to the liberation of Palestine, and she's a proud co-founder of the Adala Justice Project. Together with her family, Nadia is currently documenting the life and vision of her grandfather, Salah Ben-Youssef, a third world revolutionary and freedom fighter of Tunisia's independence movement, who was assassinated in 1969. And now I am so excited and delighted to leave you all in the capable hands of Nadia. I'll pass it over.
Thank you, Lauren. Thank you all so much. To all of the organizers, student organizers, which you will talk about also a little bit later today, are the heart of so much of the work, and really, really proud of what you've pulled together and the kinds of questions that you're asking. My name is Nadia Ben-Youssef. I use she and her pronouns. I am a light-skinned Arab woman with curly dark hair. I'm wearing a beige shirt, and I'm calling in from Lenape land in Manhattan. And it is really an honor to welcome you into this colloquium and into this conversation. We're going to be talking about the criminalization of dissent. The title of the panel is What is it? And I think equally important is why. Why is it? What ideas, future visions, demands are being suppressed? Which communities? What makes the empire tremble so much that dissent, resistance is criminalized? We have an awesome panel, and I want to invite folks to join us on the screen. Tej, Nagaraja, Carey, Shenkman, Sean Hill, Emerson, Sykes. Welcome all. It is such a pleasure to be with you. I was saying as we started that I've been Googling and watching videos, and so it feels like I'm with celebrities in this room. You are going to learn a lot, scholars, activists, organizers who think a lot about this topic, what it means to our movements, how do we resist it? And you should have received the brochure where you're going to see the full bios of our panelists, and invite you to look into that. It's impressive work. It's life-affirming work that they're doing in the classrooms, in courtrooms, as writers, as organizers. So follow their work. It's an honor to learn from you and to be in this conversation. And the hope is that we dig in and that the colloquium feels grounded. You're going to be moving through campus activism, the criminalization of justice movements, and ending with an amazing panel on resisting and surviving the criminalization of dissent. And we want to think about the theoretical underpinnings and the history. This is obviously not a new thing. The last colloquium was on settler colonization. Of course, we can trace a lot there. And so we're going to go through some of this. There's some targeted questions, and I invite folks to jump in with questions of your own. We'll be doing some questions till around 5:30. So we have about an hour, a little less, that we've worked on together that we hope will guide the conversation. And then there'll be about half an hour for you to answer questions. So welcome. I would love for you each to introduce yourself, your work, and situate yourself in this story. Why are you here? What does the criminalization of dissent mean to you? What do you hope to offer to participants in this space? We're being joined by over 90 people online right now. Folks want to hear, want to learn together. So situate yourself in this story. And Tej, I'm going to start with you and then go down the list. And we're going to spend 3 to 5 minutes, each of you offering us kind of an orientation to you and to this work. So Tej.
Great. Well, thank you to Nadia. Thank you to the organizers, the students, the workers, and all of you people of conscience attending this event. It's my pleasure to be part of it with so many wonderful people. My name is Tej Nagaraja. I use he, him pronouns. I'm a brown-skinned, black-haired person sitting in New York State on the homelands of the Cayuga Nation. And I come to this right now. I'm a history professor, and I teach and write about the history of the United States, the history of US government policy, and the history of social movements. And I also come to that work as a person who came of age in a certain moment. So I came of age in the moment around the turn of the millennium, around the year 2000. And very much grounded in New York City at the time. This was a place in which local and global events of social, economic, and global justice were deeply interlinked for me and for a lot of other people. The torture of Amadou Diallo, the torture of Abner Louima, and the killing of Amadou Diallo by the NYPD showed the anti-Black violence of everyday and extraordinary state repression in New York City, targeting Black and Latinx people, as well as people, in this case, of Caribbean and African migration. And the response to that and the mobilization by a multiracial coalition, African-American, Latinx, Caribbean, and African communities showed the links between the local and the global, between sort of the repression that happens every day against working class people and targeted communities, as well as against activism itself. And then within a couple of years, with the US response to the 9/11 attacks, we saw a new era where the NYPD's repression against working class people of color was emboldened by a new Homeland Security mandate, by a new Islamophobic and anti-immigrant mandate targeting communities that were perceived as Muslim, as well as wider communities, Black and otherwise. And of course, with a foreign policy response in the wars of that moment. So that brought me to the study of history and looking back at the history of the United States and the connections between intersectional social and economic justice and global justice, from World War I and a time of labor movements and US power projected abroad, and repression of those labor movements, particularly anti-immigrant targeting in the name of Americanism, to the era of World War II and the Cold War, where we saw labor movements, multiracial labor movements, especially with Black leadership, immigrant and Jewish leadership, facing repression. And the second Red Scare of McCarthyism in the 50s, linking both, again, everyday social and economic justice struggles with the repression of more extraordinary activists. Everyday repression targeting working people and people of color, as well as targeting frontline activists. Again, we see that in the 60s and 70s, the era of the Black freedom movement and the anti-war movement, and especially the link between those racial justice movements and anti-war movements in the Vietnam era, with COINTELPRO repression and the way that activists organized and responded and educated themselves in a moment of trauma, in a moment of enormous destabilization to respond. And we see how that echoes in the post 9/11 moment and in our own times, in the era of the No DAPL movements and indigenous sovereignty movements, Black Lives and other anti-carceral movements, and these frontline struggles now against new forms of reaction, Florida being one, obviously, front line. And there we see especially the targeting, again, of everyday working class economic justice, schools and libraries being the frontline places that are being targeted because they serve all people, because they are public for all people, especially working class people, and because schools and libraries are places where people might come into their own. They might read, they might engage with ideas, they might talk about affirming Palestinian life, talk about affirming Black life, talk about affirming trans and gender nonconforming life. So I think with all these things, you see the connections, the intersectional and the international struggles of economic and social justice with repression of more overt activism. And so things are different in different contexts, but we can also learn. We can learn from the different modes of repression, as well as learn from the different modes of freedom movements pushing back against them. And I'm really looking forward to learning more from all of you today.
Thank you, Tej. So you heard who's being targeted across history. That's why you get history professors in the room. That'll tell you stories, right? Our history is our present, is our future. Talked about working class people of color being targeted, immigrants, labor movements. These are both kind of everyday repression and then ideological attacks that spike at different moments, right? And so appreciate you kind of naming those modes of oppression and then ending us with what are the modes of resistance, which I hope we'll get to too. So Carey, welcome, and introduce yourself, situate yourself in the work. Why are you here? What do you want us to know?
Thank you so much, Nadia, and to everyone on this panel and folks who've taken time to be here. It's truly an honor. My name is Carey Shenkman. He, him pronouns. I'm light-skinned, white and male-bodied. I have brown hair. It's in a bit of a mop. I'm in a brown jacket and blue shirt, and also paint my nails red, although it's kind of coming off now. Actually, my background in my office is one of my favorite things. It's the Hobo-Dyer equal area projection, which places the global South upright and the continents of South America and Africa in their realistic masses. So I actually regularly challenge folks that consider that a issue or ask questions saying, oh, why is your map upside down? Because I think it's a great way to challenge our assumptions of how we frame space and even talk about our world. So about me, I'm a human rights lawyer, actually an NYU law alum from 2013. I worked for several years for the late Michael Ratner, who is one of the early very important lawyers with the Center for Constitutional Rights, where I was also a fellow during law school. And with him and since, I've focused on the defense of folks speaking truth to power, kind of under the umbrella of free speech and digital rights. Over the past several years, I've also done a lot of religious freedom defense for Muslim American communities, pro bono assistance to folks behind bars, including updating CCR's jailhouse lawyer's handbook. And I also have some clients that include movement spaces such as the People's Forum in New York City. So folks have been by there. I very highly recommend it. It's a wonderful, wonderful space. So one of the main reasons I'm speaking to you today regarding dissent is research that I've been doing for close to a decade surrounding the Espionage Act of 1917, which has been in the news actually lately because it's been used to investigate Donald Trump and now I guess Biden as well. But more importantly, it's the premier law that's used to go after truth tellers, from Chelsea Manning and Edward Snowden to now seek the extradition of Julian Assange in what may well be one of the most important First Amendment cases in US history. So in doing that work, what I've really tried to do is situate these modern cases in a political context of information control and dissent. And I think what really embodies that was a conversation that I had many years ago at a conference. It may have been in Germany, but there were many folks from the MST, a group that I think many on this at this conference would be familiar with. It's the Brazilian landless workers movement, but they were fervent supporters of folks like Edward Snowden, of Chelsea Manning. And it was something that puzzled a lot of us, that why does this landless workers movement, why is it so supportive of these white digital rights advocates and US whistleblowers. I mean, isn't this a bit removed? And the answer was short, but so powerful. It was that they're fighting against empire. And I think that really embodies what's at stake in so many of these cases and what we often don't hear in the mainstream conversations about them. So in my book and my research, and hopefully that we can get into this conversation, I'd like to situate those cases in that important history.
Wow, Carey, that's awesome. And love the CCR connection and Michael Ratner presente in this space. You talked about, you know, the defense of folks speaking truth to power, that there are tools, legal tools, political tools, policies that are used to suppress dissent, the Espionage Act being one key one, you know, going after truth tellers, you said. And this is it, the fight against empire, right? Like this is what is so threatening, and this is what needs to be suppressed by all means. And we're going to talk about those means that the state uses to go after those who are really critiquing empire, critiquing racial capitalism. We're talking already about race and class in this space. So thank you for that. We're going to dive in a bit. First, would love to hear from Sean Hill. Hi, Sean, and who are you? Welcome to this space. How might you situate yourself in this conversation about the criminalization of dissent?
Yes, thank you so much to all of you for this invitation and this opportunity to speak in more detail, both about my practice experience and how I incorporate that into my teaching. So my name is Sean Hill. I'm a cis Black man. I use he, him pronouns. I have glasses, an afro, and I'm currently wearing a cream turtleneck, and I am calling in from Columbus, Ohio, the Ohio State University campus. So there's so much that I could speak to with those wonderful questions, but I'll just quickly go through a bit of my practice experience, what brought me into the movement lawyering realm, and then a bit about, what I've been doing since moving into the academy. So I practiced for 6 years total in New York City, and I originally started off as a direct legal services attorney, and I was working with young people under 24 on the host of collateral consequences that they were dealing with because of a criminal record. And so I was practicing as a generalist attorney. So pretty much representing, if you were a young person or my client, I represent you on anything that was impeding your successful reentry. So that might involve custody, visitation, and child support, so that you have strong bonds with your family, criminal defense work, criminal record error corrections, and a host of other licensing work, civil as well as criminal work. And, I was really passionate. I loved the work. I loved the young people that I was working with, but I was finding that I was increasingly frustrated, particularly because of how I was positioned, which was practicing one day in family court, another day in criminal court, another day in maybe an administrative hearing. And what I was confronting were all of these barriers that my clients were confronting in terms of leading successful, thriving lives. That even if they were able to remove these barriers because of a criminal record or otherwise, that they were just going to constantly confront all of these impediments to their success and the success of their loved ones. And because of that frustration, I was motivated to seek out some alternative sites beyond traditional legal practice. And that eventually brought me to the National Conference of Black Lawyers, which is a collective first formed in the 1970s. And it was the legal arm of the Black liberation movement. And it was an organization that represented individuals like Angela Davis, Assata Shakur, and they had they were still working, but they weren't as active in New York at the time. I became a member, immediately excited about the work that they were doing. And namely, we started building a legal observing apparatus where we were supporting folks directly who were engaged in protests, supplying that legal observer support by observing what police were doing. And we also built out jail support and other avenues to support individuals who were being criminalized for engaging in protests. And then that eventually led to me being connected to the Law for Black Lives. We held a conference in 2015. And all of this was deeply empowering for me in a moment where I felt not just the frustration of practice, but, you know, I think as a Black or brown person witnessing the end of Black life, its portrayal in media, the lack of nuanced conversation about the loss was really impacting me. And I felt so disempowered while I was engaged in something that I was passionate about, but I just felt as if I was coming up against a wall constantly. So ended up doing this work with NCBL and Law for Black Lives for several years. You know, was able to connect with other attorneys, other legal professionals, as well as organizers, and really engaging in the collaborative work that I think is a core feature of movement lawyering. And I'm happy to speak about that further a little bit later on. So did this work, as I said, for quite a while, several years. And then I decided to make a transition into the academy for a host of reasons. But I would say that, you know, topping the list was I personally wanted to build an understanding of what I was witnessing and to have a bird's eye view of the issue, right? Like I was confronted, you know, I was reading lots of material on my own, but I wanted to have time for extended study that I could then share with the communities that I really cared about. And so part of the motive wasn't just this opportunity to influence law school students, but being able to build a knowledge base that I can then bring back that knowledge to the communities that, you know, I had been working on behalf of and that I identified with. And so, you know, my work in the academy thus far has taken me to quite a few areas. I've done work on bail reform and algorithmic risk assessment, but more recently, where my focus has been reconstruction and the series of cases that the Supreme Court heard immediately after the abolition of slavery, when you have Congress, you know, passing a series of laws like the Civil Rights Act, as well as the enforcement acts, which were intended to allow Black people to become citizens, to participate as citizens, to exercise things like their First Amendment rights. And you had the enforcement acts, which are passed because you have both individual and collective acts of white violence that are happening on a national scale at the time. So Congress, the federal Congress, passes this legislation that is both intended to incorporate Black people into the social contract, while also establishing criminal liability if you were, you know, attacking Black people or Black communities. And what we witnessed during that era in particular is the Supreme Court rolling back all of these series of advances. And so I think that the history is especially relevant given the moment that we find ourselves in. And again, looking forward to further expanding on my remarks, but thank you again for this opportunity to speak with you all today.
Excellent. Thank you so much, Sean. So gave us also things to look into. If you're not familiar with the National Conference of Black Lawyers, look it up, follow their work, continuing legal arm of an ongoing Black liberation movement and freedom struggle, and doing incredible work also internationally. Thank you for rooting us in the story, the history, and thinking about Reconstruction, thinking about this line that you said, you know, as a direct legal services attorney, hitting that wall, those barriers for your clients to lead successful and thriving lives, the barriers of racial capitalism. And I think so much of what we're talking about too, you know, the the resistance that's being stifled to that, to inequality, to racism. You know, these are challenges to white power. These are challenges to the ruling class. And so we need to suppress them and stifle them as much as possible. So I think repression is the policy answer to economic inequality, to poverty, to racism. That's how the state is responding to such things rather than investing in communities. So appreciate you lifting that up. And to close us off on these sort of introductory grounding is Professor Emerson Sykes. I think I don't know why I said professor to you, but it's just at the end because these are all professors. But Emerson, why are you here? Situate us into this story of criminalization of dissent.
Well, I'm definitely the least professor of the professors, so I don't know why I got that distinction, but thank you, Nadia, and thank you to the organizers. It's a pleasure to be here, at least virtually. My name is Emerson Sykes. I'm a senior staff attorney at the American Civil Liberties Union at the ACLU. I work in the national office on the Speech, Privacy, and Technology Project. I'm a brown-skinned African-American cis man. I've got a beard, it's black and gray, and I'm wearing a gray shirt. I'm calling in from home in Brooklyn. So my current role at the ACLU centers around litigating First Amendment cases. We also do public advocacy and other sorts of things like this colloquium, but my primary role is in litigating First Amendment cases. And those include right to protest cases. I focus on campus speech issues broadly. And in general, my docket sort of sits at the intersection of free speech and racial justice. And the only reason that I am a professor is that I'm right now an adjunct teaching a seminar on race and the First Amendment at NYU. I see a couple of my students in attendance, so hello. So the main reason I'm here is because of my job at the ACLU and because we, for 100 years have been litigating these First Amendment cases. We can get more into sort of the history and the background. I would also say though that my journey to the ACLU, I've been at the ACLU for about 5 years now. And before that, I worked in international human rights at the International Center for Not-for-Profit Law, where I ran our programs in Sub-Saharan Africa. And there I was working on freedom of association, freedom of assembly, and freedom of expression as regional norms that were being implemented on the national level. And that was very much about defending dissent. If I were in my office right now, you would see multiple ACLU branded posters with the words dissent on them in different fonts and colors. This is a main theme of the ACLU's work. It was a main theme of my work internationally. We were working with political dissidents, LGBTQ activists, environmental activists, human rights advocates, all sorts of folks who were in some way inconvenient for those in power. And it was through that work, sort of protecting what we called civic space, that I came to work on First Amendment cases in the United States. When I was at NYU over a decade ago now, I was very much focused on international human rights and political change specifically in Africa. The reason for that, I'll go backwards and then I'll recap up to today. So the reason that I became so focused on sort of supporting dissent and political movements in Africa was a journey in 1997 when I was a kid to South Africa, post-apartheid South Africa. And seeing, Mandela was president. Obviously, South Africa is a complicated place. It continues to have a variety of issues, but I was there in a post-apartheid moment where the legal system had changed, the political structures had entirely changed, and the face of the country overnight was dramatically different. And seeing that firsthand really sort of stoked my passion and how we create this sort of society-wide structural change that really can impact people's lives. Again, South Africa is complicated. That was not the end of the story, and it's not a perfectly happy ending, but whatever happens, we know change is inevitable. It might not be positive change, but there will be change. So my work, sort of the through line has been trying to figure out how we can help folks make sure that the rules and the laws of a society protect the space for dissent. And so that's central to my work at the ACLU now, and we can talk a little bit more about that later.
Thank you, Emerson. People who are inconvenient to those in power. That's a through line. People who are inconvenient to those in power. Those are the people who need to be criminalized. That's the speech that needs to be suppressed. Those are the ideas and visions and demands that cannot be tolerated by the status quo. The people who are inconvenient to those in power. Before we dive into just some specific questions, because I want each of you to be able to go a little bit deeper into your work and into the lessons that you want us to take into the rest of this colloquium. But I'm wondering if we can do just a quick round, because so often we're talking about how the state is the modes of oppression that the state is imposing on our people and our communities, the people that we love, the people we're in struggle with. It's a painful reality right now. You know, Tej, you talked about Florida. I know folks are going to be talking about Cop City tomorrow. You know, it's a painful time of incredible violent repression. And the short go around and the invitation to you all, because I know you've thought about it, but we don't spend enough time there. I think artists spend a lot of time there. But Emerson, you made me think about it because of the South Africa example of like the world can be radically different. This is why we're here. We're fighting for a radically different world. And I guess, you know, if we could just name it, start naming that world for us, right? Like what is being silenced? What possibilities are being repressed, criminalized, codified into law that you cannot say this, you cannot speak this, you cannot organize for this? What's the future vision? In a sentence or two, you know, from what you've seen, from what you are struggling for, what your communities are struggling for, what is being suppressed? What is the vision of that world? Just paint it for us. You're all writers and poets and lawyers, I know. Paint it for us. What is that world that's being suppressed? And then we're going to dive into just how it's being done. But the first is like, what is it? What is it? Can we say it? So Tej, I'm sorry to start with you. I know it's a big question, but can you just paint that world for us in just a bit of time?
Well, you know, I think part of what we're finding, and I mean, I think it resonates across what different people have spoken about. I mean, the possibility of solidarity, right, is a threat, right? The possibility of solidarity is a threat for reform in the short term, right, to make a more democratic and more just society, and for radical possibilities. You know, Sean Hill spoke about, you know, the Reconstruction moment, right, which was a threat of Black liberation and a threat of multiracial solidarity, right, of white-Black coexistence and people seeing common interests. We can think of the post 9/11 moment and the sort of Islamophobic targeting of people who were designated as being from Muslim majority countries, and more recent responses to sort of Black lives and sort of Palestinian assertions. The possibility of sort of people seeing themselves as in the same boat, as shoulder to shoulder, is very real, and it is compelling to not everybody, but many people at different times, and that's a real basis and rationale for repression and trying to preempt even that possibility, and to create a chill such that people don't take that step or people don't voice that possibility.
Beautiful. Carey, what's the world the truth tellers are trying to bring into existence? What is that world?
I think it's a world where the First Amendment of the US Constitution and Article 19 under the International Covenant of Civil and Political Rights are given true effect. Because as long as truth tellers can be prosecuted in the US or in other jurisdictions when they actually challenge and utilize those rights. As long as that's happening, then they're just words on paper.
Thank you. Sean, tell us about the world.
Yeah, I had a chance, to take a look at that question before we got together, and I had jotted down several things, but I'll focus on two. I said first, public safety that is not defined in terms of jails, prisons, and police, and the construction of life-saving, life-sustaining, as opposed to death-making institutions. And I confront this in so many ways, both in terms of talking to my family, who are working class Black people, some of whom have been the victims of, harmful acts, have been incarcerated. And even when I talk to them, let alone in a law school classroom, just asking questions, what do you think you would have needed in this moment after you experienced harm? Don't you think it would have been wonderful if the things you needed were actually funded by the state? In that moment where you're being told that the solution to your problem as you're recovering from the emotional trauma, the physical harm you may have experienced, what would it look like if you received therapeutic services? What would it look like if you got to influence the process of confronting someone who has harmed you? What would all of this look like? And these are the questions I'm both posing, to friends and family. I am posing in the law school classroom. And what I'm confronting is how little space we have for those conversations, that so many folks confront language pertaining to things like abolition or divestment, and they have, understandably knee-jerk reactions based on how this is portrayed by our institutions, particularly mainstream media. But then when you actually have conversation with people and you ask them, what would you have liked if you're in fact are a survivor of sexual assault, if you're a survivor of a crime, what did you need in that moment? And did anyone ever ask you what you needed? What could have been provided to you? And so often what I find is folks are deeply receptive to these conversations, but what we confront too often, I think, which was what inspired your question, is it's the fact that we have no space and no opportunity to discuss the world that we could actually live in.
Oh, yes, thank you, Sean. Emerson, take us home. What's the world?
No pressure. I think, there are so many ways in which people are dissenting that, suffering under the criminal legal system, that are matters of life and death, that are about climate change, these real sort of tangible harms. But my work really focuses on the free speech work that creates the room for us to have progressive ideas about who we are, about how we talk about our own history and who we are as a people. So I've been working, it's a little bit different than what we're talking about today, but a lot of my work recently has centered around these bans on inclusive education in Florida and elsewhere. And I think the vision that terrifies the folks who are trying to put in place these bans is challenging these dominant narratives and challenging how we understand and talk about ourselves and our history, and the vision that we have of a more inclusive education where people see themselves and their narratives reflected, and where scholars have the freedom to push boundaries and to call people in power to account. That's the vision of the future that I'm focusing on, and one that I think is terrifying Ron DeSantis and many other people.
Friends, that was so dope. The world that is being preempted, the possibility, preempting the possibility of the world, the world that is so threatening to those in power is a world of radical possibility, where multiracial solidarity and Black liberation is thriving, where public safety is defined by life-saving, life-sustaining institutions, where there's the space, to tell the truth and that it's actually protected. And where there's the space to imagine that world, to discuss that world, to think together, to be educated about the possibilities of that world, right? So this is what's threatening. This is what's threatening to the status quo. We're going to have 20 more minutes where you each will kind of dive in a bit more into your work, what it is that you want us to know as we go into the future conversations of the Colloquium, and all of us as movement lawyers, as activists, organizers, community members want to learn and think about as we move forward, and lessons that you think are really important. There's going to be a time where I interrupt, and it might be soon, to give the CLE code, so folks can just keep that in mind. Unless I can do that now, I'm looking to the organizers, because I think my time to do that is in 2 minutes, and I don't want to interrupt, but I might have to, Tej, if we're going to move forward. And you will get the CLE code very soon. Oh, no, you can do it now. And in fact, take out your materials. Do I have the CLE code is the question. I have it. Ready? Chair 7. So capital C, H-A-I-R, number 7. The CLE code, there's no space in between, so don't mess it up, which is capital C, H-A-I-R, number 7. Folks have it? That's all I can say. I can only say it twice. So strange. But you'll have more opportunities if you stay tuned for the rest of the Colloquium. Okay. Friends, we have 20 minutes and then we'll open it up for questions. I know that there are some questions coming in, which is really exciting. There's some really good things coming. So get excited, folks. Have your questions ready, because this is a great opportunity to meet with these folks and to learn from them. So Tej, we're going to dive into racial capitalism because we have to, right? We have to talk about why the labor movement has been the target of suppression. And you can give us, you've given us in your introduction kind of a bit of a history, but again, like the why feels significant. And if there are particular ways that suppression has manifested, just let us know so that we can be, as comrades in this work, attentive to those modes of oppression that the state has done, particularly to workers and to the working class. So Tej, lead us into the why of the labor movement is the target of suppression.
Sure. Well, I'll just make a couple of points to think about the historical perspective and bring it to our own times. We've talked about the history, right? Sean Hill talked about the Reconstruction moment, right? Which for a deep democracy of interracial and economic democracy is a critical resource for us to think back on the 1860s period, where enslaved people emancipated themselves and other people, including some sections of white people, stood shoulder to shoulder with them in trying to recreate a new society. And so that possibility of solidarity is formative to any project that links social and economic and global justice, and breaking that and preempting that and dividing that and creating a chill to prevent that is similarly critical for the other side. The First Amendment, and I think Carey Shenkman has talked about the World War I moment. The First Amendment only became meaningful because the labor movement and other movements tested it and made it popular. When the First Amendment was enshrined in the Bill of Rights, there wasn't necessarily millions of people talking about it and going around saying, I have my First Amendment rights. That was something that only happened over generations, and especially the industrial workers of the world, labor movement of the 1910s, engaged in free speech fights. And those 1910s fights linked free speech and the right to actually use the First Amendment, which it only matters if you test it, with struggles for interracial, interethnic, pro-immigrant politics, with pro-birth control politics, which is really formative for our time when reproductive rights and birth control are under attack. The labor movement and the free speech movement was very focused on birth control in the 1910s and 1920s. And so the attack was intersectional too, right? With the Espionage Act, the Sedition Act, alien and anarchist acts, which attacked immigrants in 1919, 1920, attacking feminism and birth control, attacking labor, and trying to break these solidarities, particularly interracial and interethnic labor movements. Through the mid-century of the 30s to the 40s to the 50s, the 60s, the Black freedom movement and interracial labor movements sought to link racial, economic, and global justice with an anti-war vision. And that too faced the repressions of those times. And similarly, we can see that in our own times. The front lines of those who faced the post 9/11 repression, Carey Shenkman talked about Michael Ratner and the Center for Constitutional Rights' role. Also, working class centered groups, the New York Taxi Workers Alliance, Dacey's Rising Up and Moving, Drum Organizing Asian Communities, organized around working class issues, right, of labor, of housing, and had the base and had the voice to organize Pakistani communities in Brooklyn and Queens that were facing special registration, facing detention and deportation in that moment. Again, new labor movements, worker centers in that period. And now I think really the front lines, the attack on teachers is so central because teachers are the front lines of a possibility of an interracial democracy, of a cross-class democracy in our society. Teachers are the ones defending public institutions for all, and teachers are the ones that are going to support their gender nonconforming students who are coming into their own. They're going to support their students that are voicing their identity, be it their, criminalized or otherwise stigmatized national identity or racial identity or gender identity. So I think that link between sort of targeted groups that have to be supported on the front lines, be it trans and gender nonconforming youth, or be it Black and other criminalized working class sectors, or be it teachers and teachers unions, or teachers without unions organizing Red for Ed campaigns in states where unions aren't empowered, is critical as we build solidarities that can amount to majorities of the population.
Oh my goodness, great. Solidarities that amount to majorities. We are the multitude. That's what freaks everyone out, right? The possibility of the multitude having power, taking power, and why the working class and worker organizing in the labor movement is so threatening, because it can create the possibilities. Thank you for lifting up teachers, Tej. I think that's an amazing conversation for us to have. I see Emerson nodding. This is his work too. You said teachers are the front lines of an interracial, cross-class, gender-expansive democracy. Yo, that's the world, right? And that's what's so threatening. Thank you for bringing us into that history and also for rooting us again, both in Reconstruction, also the turn of the century, what that meant and why workers are leading, it's yes, a free speech methodology of resistance, but it's creating social, economic, and cultural rights that destabilize the status quo. I'm going to switch it up because you were referencing Carey a lot in your response. And so Carey, sorry to put you on the spot, but I want us to dive into, in part because of the historical approach that you take in your book, A Century of Repression, which is detailing how the Espionage Act was deployed against key movements across the 20th century, particularly anti-war resistance. But how, in your work on this text and on this, and in defending those who are targeted and criminalized by the Espionage Act, what do you think is the most important thing for us to take from that history whether it's the context of political repression in which it emerged or who the targets are. Kind of give us some of the nuggets. And of course, folks should read this book, and you'll have an opportunity to see it probably in the chat. But tell us a little bit about the Espionage Act, why that's the focus of your life work and the scholarship right now. So fill us in.
Thank you so much. And thank you, Tej, as well for those references. I think the one takeaway I recommend for folks is with any law, not just the Espionage Act, but any piece of legislation, to not buy into the US government's framing, the US government's vernacular. And one of the arguments we make in our book is that the Espionage Act is actually one of the best branding campaigns of the 20th century, because it doesn't, the way it was used when it was passed was not about espionage. When you or I hear that word, we think of folks who are being paid by a foreign government to spy, to pass information in secret. But that's not what the first few thousand prosecutions were about. In fact, Thomas Gregory, who's Wilson's Attorney General, made clear in his annual report in 1917, when the law was passed, that domestic unrest was a primary concern in its enactment and enforcement. It was passed actually just a couple months after Wilson declared US entry in the World War I. And he, in his speech declaring that entry, talked of the threat of disloyalty and said that disloyalty would be met with, quote, a firm hand of stern repression, calling for the Espionage Act. And then what followed is the first sedition act that the country had seen since the Alien and Sedition Acts. So we had these prosecutions for seditious libel. The Wobblies, or the industrial workers of the world, were prosecuted in a mass trial of over 100 people. The socialist publication, The Masses, was also prosecuted, as well as Eugene Debs after his Canton, Ohio speech, which was considered one of the most important protest speeches in history. He actually ran for president famously from behind bars for an Espionage Act prosecution. So I think for many folks who are legal scholars or law students, you hear about a lot of these cases in con law, like the Pentagon Papers case, New York Times versus United States, which was about prior restraint when the Nixon administration tried to stop the New York Times from publishing the Pentagon Papers. That was one of the most important First Amendment cases of the 20th century. But behind the scenes of that was the Espionage Act and discussion among the justices at the time of whether that law could be used to prosecute the press. And that's still an unsettled question right now in the US, because this law is so broadly drafted as to allow for the prosecution of any individual, including you or me. It doesn't have to be a US government employee, doesn't even have to be a US citizen, as we see by the Justice Department's current attempts to extradite Julian Assange, not for anything alleged surrounding 2016 or emails or the Trump administration, but going back to 2010, the publications surrounding Cablegate and the Iraq and Afghanistan wars. So when we look back on this history and we see these prosecutions and that political history, it's really important to draw that line between how we see the use of that law today and back then. You look at careers like that of J. Edgar Hoover, who was hired as a 22-year-old at the Justice Department. And his first cases were actually enforcing and prosecuting, investigating Espionage Act cases. There was a huge racist thread to those prosecutions and investigations as well. Hoover, in the beginning of his career, was obsessed. He was so preoccupied with Black publications, including the Chicago Defender, the Baltimore African American, and the Crisis. There were editors that were prosecuted under the Espionage Act. Marcus Garvey was targeted. And Hoover even published a report called Radicalism and Sedition Among Negroes as Reflected in Their Publications, and famously warned, quote, "The Negro is seeing red." In fact, this racism followed in the interwar years and also through World War II. And in a thread that's really not talked about enough, that under the Roosevelt administration, the Justice Department was actually monitoring and considering prosecuting anti-war African-American publications. There is a big showdown actually between the young editor of the Chicago Defender and the Attorney General at the time. But at the time, actually, there was a lot of call out to the FDR administration's failure to support anti-lynching legislation, the hypocrisy of trying to fight fascism in World War II in Europe, but yet promoting segregation in the US, having a segregated military while still requiring the service of African Americans in that military. So during all this time, Hoover was actually pushing for these prosecutions. And something that we argue is that you can really draw a line through this political development of Hoover going up to the 70s in COINTELPRO, and the way that these monitoring of dissent and the racist undertones of that played out. So I think one of the key takeaways, kind of bringing full circle, is all these cases targeted anti-war movements, they targeted dissent, they targeted opposition and the revelation of information during wartime, whether it was World War I, World War II, the Cold War, during the McCarthy years, or now in information wars and modern surveillance wars and the so-called war on terror. We see these threads of how this law has been applied. And anytime that there are conversations surrounding whistleblowers, surrounding insiders who are revealing information to the press, whether it be under the Obama administration, Trump administration, or now Biden, we have to situate that in these very early attempts to suppress dissent and control information.
Wow. Give it up for the historians in the room. I am grateful for that lesson. And you brought us really into a powerful moment for Professor Hill to join the conversation too, about just that extended reflex to criminalize the Black freedom movement, prosecute organizers, those who are dissenting the status quo. I think it's so crucial for you to have drawn that line for us, Carey. And there's one piece that you started us with, which I love, which is don't buy the government's framing, right? Because we're about to hear, and Sean, I'll turn to you about the movement for Black lives and the FBI characterization of the movement for Black lives as Black identity extremists, kind of extending the COINTELPRO characterization of Black organizers as threats. I'm sure later on in this series, we're going to dive into domestic terrorism as a label, as folks explore the Cop City prosecutions, but also we're here now, right? The federalization of charges against protesters. When you think about the 2020 uprisings too, what are the charges against folks now for work to disrupt the status quo? So thank you for that. And I'm going to turn it to you, Sean, to reflect on that, the criminalization of this current Black freedom movement, and the work that you have done to try to shift those narratives, to change policy, to internationalize this struggle, to contextualize it into this broader story.
Yeah, thank you. So I will speak to direct interventions that movement lawyers are making right now in terms of protecting the ability of marginalized communities to dissent. But before I move there, I did want to emphasize in our conversation about criminalization of dissent, we rightfully focus on if you are incarcerated, if you are subject to arrest or imprisonment as a result of engaging in protest. This is very clearly instances of the silencing and suppression of alternative voices. But I think it is equally important to understand how under enforcement of criminal law has also contributed to the silencing of dissent, namely the series of cases that I made reference to in the wake of the abolition of slavery during the Reconstruction era. Many of these cases arose from white mobs organizing against Black communities that were engaged in dissent. And that might have entailed them engaging in electoral politics. It might have entailed them engaging in traditional protest and demonstration. But what we see in terms of the legal cases is individuals, white defendants who are prosecuted by federal prosecutors because state prosecutors were completely disinterested in pursuing criminal charges. Federal prosecutors who proceeded to use federal legislation in order to prosecute the perpetrators of, large, wide-scale violence, they successfully obtained prosecutions at the trial level. And then once it reached the Supreme Court, they vacated the convictions and engaged in a series of legal interpretations that justified why these defendants could not be held criminally liable, right? And these were not public officers who we traditionally associate with the suppression of dissent. These were civilians, these were private citizens, right? So I think that it is important when we are discussing criminalization that we appreciate that the under-enforcement of criminal law has been integral to the suppression of political dissent, and that we situate instances like Kyle Rittenhouse or January 6th protesters, that we situate them within this very long history of under-enforcement of criminal law, which is also intended to silence dissent, silence individuals who are engaged in the work of lifting up alternative visions. So with that said, I did want to speak briefly about the role of movement lawyers in this moment where you do have, leaders of Black movements being labeled as Black identity extremists, and where exactly do attorneys and lawyers fit in here. So I think, what is integral to movement lawyering is collaboration, is understanding as attorneys that we are not the exclusive or primary source of expertise, and that we have to listen and understand and appreciate the demands and the objectives of directly impacted people and support them in executing selected strategies. And that was the Legal Observer group that we created. We traditionally associate that with the National Lawyers Guild, and part of why we built the NCBL Legal Observing contingent was because Black and Brown movement leaders were saying we would like to see more legal observers that represent our communities, that would make us more comfortable. And I think that that is very much representative of what is necessary in this moment is the folks who are doing this work day in and day out, they have clear visions. And too often as attorneys, we might come in and say, well, we've got the legal intervention or the legal solution, and it's significant, essential that we are listening and understanding how can we collaborate and how can we support in accomplishing these objectives. It means that we have to develop our own understanding of the demands in this moment, right? So yes, as attorneys, we might have different platforms to speak to audiences that otherwise may not be familiar with these demands. And so I think it's important that we ourselves familiarize ourselves with those demands. And we have fabulous templates. The Movement for Black Lives, the Law for Black Lives, they've released a series of proposals over the last several years, bills, what are called non-reformist reforms, what are not going to move us away from an abolitionist horizon, right? So we have the model, and we merely need to build our knowledge and our understanding of what does this vision mean, what does it entail? And I think that there are just a host of ways that we can be supporting. I've already described one, which is as legal observers. You monitor police and their tactics when individuals are engaged in protests. You can supply jail support by taking down details of arrests, details about the person arrested, connecting them to necessary resources. The infrastructure is already there. As I mentioned, the National Lawyers Guild and NCBL both have implemented these types of legal observer programs. providing general legal support, building defense networks, drafting legislation, reviewing legislative bills that organizations have generated themselves. And I think most importantly is identifying needs, talking to people and being engaged in collaborative and collective struggle is very important to, work side by side and not imagine that one needs to take the lead in any way.
Thank you, Sean. Lessons in movement lawyering. I hope folks have heard that. There's a lot of invitations of how we show up for movements. Lessons in the abolitionist horizon that we are moving towards and building towards, getting familiar with those demands. So thank you, Sean. We're going to integrate some of the questions now that are coming into this next round. And I'm starting with you, Emerson, because I wanted you to have a chance to get into a little bit more of the First Amendment protections and your commitment to First Amendment protections. But also there's a question in there. Professor Justin Hansford is in the room and is also asking, in an environment where suppression of hate speech online has been framed as censorship in violation of human rights, how is it that the First Amendment doesn't protect speech that teaches about critical race theory? Don't teachers have free speech rights also? So the question is, talk to us about the First Amendment, what it offers us, what it doesn't, and if you can address Professor Hansford's question, that would be great as well. And then we're going to take a couple more. Amazing.
Justin Hansford is another actual professor, so it's an honor to field his questions. So I'll give you the 1 minute on the First Amendment. Look, the First Amendment is about protecting us from the government's authority to decide what ideas are okay and what ideas are not okay. I mentioned this class I'm teaching this semester. It's more than a small soundbite of sort of like untangling all of the good, the bad, and the ugly of the First Amendment. But I'll just quote an NYU and ACLU legend, Bert Newborn, who talked about the 5 freedoms of the First Amendment being read together in a logical order. And it's what I call an activist reading of the First Amendment, right? So the First Amendment says Congress, the first word of the First Amendment is Congress, right? So it's about the government's ability to regulate private speech, right? Congress shall make no law regulating these 5 freedoms. And so unlike international human rights, as Carey and others have mentioned, where it's about the rights that we all have inherently as individuals, everyone has the right to freedom of association. All people have the right to freedom of association. All of the framing is in terms of the rights that we all have as individuals. The First Amendment, very specifically, is about constraining government authority. So that's one sort of, the First Amendment is one piece of the broader conversation on free speech. So then we get into what does the First Amendment protect and not protect. And what I say in a nutshell is that it protects the journey from an idea to a movement, because it protects your right to belief, freedom of religion. It protects your right to speak. It protects your right to publish. It protects your right to assemble, and it protects your right to petition the government, right? So you have the right to think something, you have the right to communicate it to those around you, you have the right to publish it across time and space, you have the right to gather folks in solidarity, as Professor Hill was talking about, and coalesce around an idea, and then bring that very idea to the seat of people in power. So in that way, we can read the First Amendment as facilitating that process. Of course, we all don't need to be told that this is a vision, this is not the reality, right? We all know how First Amendment rights are violated on a daily basis. That's why we all have jobs. So like I would say that that's sort of my overall approach to the First Amendment. And as I was just telling a colleague, there are all sorts of reasons that I think the First Amendment is super important for both inherent reasons, the idea that we all should have these rights, that we all have these ideas that we have the right to, but also for, more instrumentalist reasons, right? We cannot have social progress if we don't constrain government's power to crack down on dissent, right? We both have these inherent rights, but we also need to have this space in order to achieve all the other goals that we have in society. finally coming to Professor Hansford's specific question, does the First Amendment protect the right to teach CRT? I argue emphatically yes. 5 months ago, I argued my first case in Florida, which was specifically representing professors that teach critical race theory, many of them law professors. Our lead plaintiff is Leroy Purnell of FAMU Law School, a fellow HBCU lawyer and law dean. And so what we argued successfully in the Northern District of Florida was that the Stop Woke Act, which was one of many DeSantis bills that curtail freedom of speech, but we argue that in as much as it makes it unlawful to teach critical race theory, and that's very much the objective of the law, it violates the First Amendment, and we were successful in getting that law enjoined with respect to higher education. What the First Amendment protects in terms of higher education is much of an open question. I think this part of the reason why this case is getting some attention is because a lot of these questions around what are the limits of the First Amendment, and what the state of Florida has argued is that in public colleges and universities, everything that comes out of a professor's mouth, and this pertains to you, Professor Hill, at Ohio State, everything that comes out of your mouth is, according to them, government speech. Therefore, the government has complete control over what can and cannot be said. We have this idea, as I mentioned, the First Amendment is about the government's right to regulate private speech. And so the question is, when the government is speaking on its own behalf, the First Amendment doesn't apply, right? Because they're not regulating private speech. The government is just expressing its own idea. But this idea of government speech has grown and grown and grown, and it's threatening to swallow up the First Amendment. Because in a situation like this, the state of Florida is arguing that this is purely government speech and that there is no First Amendment interest on behalf of the professors. This is contradicted by lots and lots of case law. There's a huge case that sort of sticks out like a sore thumb. It was written by Justice Alito, unfortunately, that says that professors don't have an individual right to academic freedom. I think that's obviously wrong, but there is a circuit split on this question. I would just argue, I know that we're running low on time, but just one more note that I have to say on Professor Hansford's question. So all of what I've said so far is with regard to higher education, where the First Amendment with academic freedom is called a special concern of the First Amendment, where everybody in higher ed, they're all adults. They're there to, let 1,000 flowers bloom and to come up with new ideas and to be creative and to push the boundaries, right? And courts have recognized that special role of higher education. K-12 is treated differently. In short, K-12 teachers do not have a broadly recognized First Amendment interest in what they teach. My wife is a K-12 teacher. My parents were teachers. My brothers are teachers. I have a lot of love for teachers. I understand that they have a lot of creativity and that this is not a fair representation of their role. But what courts have said is that unlike in higher education, in K-12 public schools, where you have a captive audience who are children who are required to be there, the state has complete control over creating the curriculum, creating the standards, approving the testing, all of those things. So when it comes to K-12 teachers, the rights that we've asserted on their behalf are vagueness and due process rights, as well as equal protection claims. It's very hard to bring First Amendment claims on behalf of teachers, unless you're trying to defend their religious rights, as we know. But as far as what does the First Amendment have to say about this? Professor Hansford, we are doing everything we can. We're litigating in Oklahoma, we're in New Hampshire, and we're in Florida, trying to get the courts to recognize the important First Amendment values that are at stake here. But we've been successful in some ways, but it's also somewhat of an uphill battle, and we'll keep you posted.
Wow, thank you so much for the Emerson, the activist reading of the First Amendment. I wish I had gotten that in law school. The idea is that this piece, it protects the journey from an idea to a movement. My goodness. Yes, thank you for that and for all the work that you're doing. I think it's crucial, and hopefully for the students in the room, for movement lawyers in the room, that telling of where we are should also remind you that the law is not the only answer. It can't be, right? We're fighting on that front for sure. You have incredible litigators in this space who are doing that work tirelessly, and it's an invitation to you to do your own work. Are you also a scholar? Are you an artist? Are you a healer? Are you a teacher? How else can you, are you a influencer? Are you creating content? How do we shake up the cultural conversation, the political conversation? What are the other levers that we can pull? Because the laws exist, some of them are good, some of them are bad, but they're also tools of the powerful, right? The law is a tool of the powerful. And I think we need to remember that too, even as we look at these constitutional protections. There's a couple more questions. We have 8 minutes left, and I want folks to also, if there are things that have come up for you that you really are wanting to get into this room. I'm looking at a question here. I believe this is your question. To what extent, and maybe some historians can answer this, but to what extent has the Justice Department and the FBI operated on their own with regard to the criminalization of dissent without the intervention of the White House, for example? So thinking about these different separations of powers and who's engaging in the criminalization of dissent, I don't know if there's someone who can speak to that question. You can raise your hand or unmute. Yes, Carey.
Sure. I think a lot of what we talk about with the Justice Department is an illusion. It's called the Justice Department, but I think so much of the time the department and really our courts serve to preserve a two-tiered system of laws. I mean, we see where in the 20th century, it's not lawyers in court that are winning victories for civil rights and human rights. I think going to that point importantly earlier, that I think as lawyers, we have roles and movements, but I subscribe to the approach of Ella Baker, which I know is close to your heart too, Nadia, which is lead from the back, or be a resource from the back, not even lead, because it's not the roles of the lawyers to be leaders of the movement. And so much of what we see actually is these court victories that get lauded are really the result of years, decades of work, of movements. And it's just then that the courts end up being responsive to that. But it's not judges and in courtrooms who are creating those victories. So going to Justice Department, I think having that framing is really important, because historically in the 20th century, you don't see these agencies following the law. So I think constantly you see them operating on their own. I mean, look at COINTELPRO. Was that lawful? I mean, there's so many things in the 20th century, and I won't get into all of it now, but we talk about this a lot in the book, how in so many of these prosecutions years later, you see the extent to which the Justice Department and the FBI are doing things like surveilling lawyers, or using legal loopholes to try to purchase people's data. This is something I looked at recently, the way that CBP and the Department of Homeland Security are actually purchasing data from private data brokers that they would normally need a warrant under the Fourth Amendment to access. I mean, it's completely wild. So always operating on their own.
You don't see these agencies following the law, Carey says, right?
And I would just add, as a recommendation of a recent book that I read that I thought was absolutely incredible. That's what I was looking around just now my office for. It's by a legal historian, Michal Belknap, called Federal Law in Southern Order, which Carey might be quite familiar with, but I think is really fantastic to deepen an understanding of how the federal system is used as an excuse, particularly by federal agencies, as a basis for why nothing can be done. And so it's pretty much state and federal officers just bouncing things back and forth and allowing, criminal cases or otherwise to simply die out by pushing things back and forth. And specifically to Hoover, I know that he was receiving instructions to actually, make arrests of individuals who were assaulting activists and organizers, and he completely ignored, all of these directives, not as if they were sustained from presidential administrations, but ultimately I think it just all points to, how the federal system can be a shield in a way to not be responsive to the criminalization of dissent.
Oh, yes. A shield indeed. There's a number of questions that we're not going to get to with regard to Cop City. Stay tuned for the rest of this colloquium, because I think it's panel 3 is going to really address the targeting of justice movements. Now, there's a question about, phone apps and know your rights. So if anyone has, while they're kind of wrapping up the last 3 minutes, can answer that in the chat. And then you have nonviolent civil disobedience and work to demand that Biden officially declare a climate emergency. This is a strategy. You've heard, I think, about the different kinds of strategies that are engaged in. Certainly, nonviolent civil disobedience is going to be criminalized too. And the work of movement and organizers are under threat for sure, just as any sort of dissident. And again, as we've said, those who are inconvenient to the powerful in any way, and certainly if you are disobedient, civilly disobedient or otherwise, you're an inconvenience. So continue that work, continue building with lawyers and particularly movement lawyers who are in the struggle with you. We have 2 more minutes left. Tej and Emerson, Sean and Carey, we just heard from you, but is there anything that you want to just put into the space as we close before the folks get into the next sessions? Tej and Emerson?
I'll just say it's my pleasure to be in conversation with you all, and I think I think that one of the key messages we're sort of coming from out of this conversation is to sort of try to be rooted in the specific place of the work you're doing and the specific role you can play, right? As we try to have a broader vision, a historical vision of past, present, and future, and a vision of the local and the global, a vision of a specific issue that you're working on, the need to be grounded, right? And the need to have sort of frontline leadership, as a couple of people mentioned, as Emerson mentioned, while we try to have these shared commitments, is really important, because we have to get at these questions, the critique of the law, the critique of lawyering, and we need lawyers to use the tools, right? And use those lines. And that contradiction and that dialectic between those two things, it might feel messy, and that's what people have been doing from previous generations, and we have to find our own way in this generation as well.
Thank you so much, Tej. We are at time, Emerson, but I want to thank you so much. Thank all of our panelists. That was an extraordinary grounding, and yes, situate yourself, know who you are when you show up into this movement space, use all the tools that you have, all of the creativity. They're going to come after us. It's because we are powerful. It's because the vision of the world that we want is a threat to the status quo. Thank you again for the organizers. This is a great conversation, and looking forward to the rest of the colloquium. I'll turn it over to Kira.
Thank you so much, Nadia. And thank you to the rest of our panel for opening this colloquium. It was a really powerful and important conversation. I felt that we were really grounded in the history of these systems, and also brought to imagine the world that we're all struggling for despite this constant suppression. So really grateful to all of you for sharing your thoughts. Wish we had more time, but there's there's always more time in the future. And thank you as well to our interpreters for their work supporting and making this accessible. We're going to break for 30 minutes, and we'll see you back at 6:30 p.m. for panel 2. Thank you all.
Good evening, everyone. My name is Haley. I use she, her pronouns. I'm a white woman with long blonde hair wearing a green sweater, and I'm calling in from the RLSC office at NYU Law. We will now turn to our second panel, Stifling Campus Activism, where we will discuss the ways in which higher education curriculums, incentive structures, and requirements make activism more difficult on campus and pull students away from organizing outside of campus, as well as how the legal profession can involve more directly to serve and advance justice. Remember, if you are an attorney seeking continuing legal education credit for this event, you must have registered with us in advance, must be currently logged into your own Zoom account, and must write down any CLE codes that the moderator announces and displays during the panel.